This week, we've had some great questions from our followers, and I wanted to share several of them with you. So, this question comes in about a step parent adoption and a biological parent's consent or failure to consent to a step parent adoption. Dear Sonia, I'm seeking guidance on adopting my stepdaughter. I've been married to her father for 4 years. She lives with us full time. Her biological mother has had minimal involvement and hasn't contributed financially or emotionally since she was a toddler. My husband and I believe that adoption would be in the child's best interest and provide her with more security and stability. However, we are unsure how to approach this legally, especially if her biological mother opposes the adoption. Could you advise us on steps needed to pursue a step parent adoption while also protecting the child's best interest? Thanks for your assistance. I love adoption work. I love step parent adoption work. The difficulty of getting to the adoption, though, is that you first must terminate the parental rights of the parent. In this case, you need to terminate the biological mother's parental rights to allow the step parent to be able to adopt. There are many grounds in the family code that would allow termination of a parent's rights, but many of them are reserved especially for cases involving the Department of Family and Protective Services or CPS, or for violations of court orders that have been put in place to make provisions that are in the child's best interest. If you can show that a parent is not following those orders, then those are some other grounds for termination. In your case, though, I understand that the biological mother has remained away for quite some time, but she has left the child with a parent. That eliminates a couple other options, but there is still one. Um, she has not abandoned the child and expressed an intent not to return. If that were the circumstances here, biological mother has left the child with father and is saying that I will not be back, leaving her with you, I am not returning, that would be a way that we could involuntarily terminate the mother's rights. Another provision to get to termination in your circumstances would be if the other parent left the child in the possession of another. Notice that this provision is distinguished because it does not require that other person to not be a parent. But the key element is that the parent has not provided adequate support. Whether or not adequate support has been provided is definitely a fact issue. There are some arguments to be made for leaving the child in the care of a parent who they know can provide for the child, but this could be an option in your case. We would need to discuss the facts a little bit more. There is another provision for termination of parental rights that is kind of along these lines, and that would be if the other parent failed to support the child according to her ability. And then the next question to determine if that would apply to your situation would be, how long has it been that there has been no financial assistance? And then the natural next question is, what is the mother's ability to provide financial assistance? I think there's a presumption that most parents can pay something. Has she sent anything, any in-kind support, clothes or gifts or toys, Christmas presents? These are questions that we would need to flesh out more in a consultation to determine if this ground would apply to you. Another ground that could possibly work is, why has the biological mother been away for this long? If she has been away because she has been involved in criminal conduct that has resulted in her conviction and confinement for more than 2 years, this is a ground that we could also use to potentially terminate her rights involuntarily. So there is another ground that would actually be the easiest. And I believe you kind of allude to it when you say, what if she opposes the adoption? What if she doesn't oppose the adoption? If you're able to talk with her either person to person or perhaps in a mediated situation during a mediation to reach an agreement for what's in the child's best interest, if the mother decides that it would be in the child's best interest for her to sign an affidavit of voluntary relinquishment, that's where she decides to give her parental rights up to allow the step parent adoption to occur. That would be your quickest, simplest, uncontested way to terminate her rights to allow the step parent adoption to go forward. By the current court orders, if she hasn't visited in a long time, you could go back to court to put some provisions in place that she perhaps do reunification therapy with the child, or that she submit to drug testing. You could enforce a child support order if she was ordered to pay child support previously. Sometimes just doing the modification or the enforcement to get the child support or medical support arrears that may be owed would be persuasive in making her see what is in the child's best interest. And perhaps she would then decide to make another agreement instead of going to court and having child support enforced or levied against her. So, there are several ways that I can assist you in making your step parent adoption dreams come true. You and your husband would need to be the petitioners together to seek the termination and step parent adoption. This would be done in two parts. First, we have to terminate, and then we can do the step parent adoption. You should schedule a consultation with me so that we can discuss in more detail the facts of your case and determine exactly what would be most advantageous going forward. I look forward to talking to you.